Judicial process. Question. Explain alternative dispute resolution system. Alternate dispute resolution mechanism. The concept and its efficacy. It is the spirit and not the form of law that keeps the justice alive. L.J. Earl Warren. The concept of conflict management through alternative dispute resolution, ADR, has introduced a new mechanism of dispute resolution that is non-adversarial. A dispute is basically less inter-parties, and the justice dispensation system in India has found an alternative to adversarial litigation in the form of ADR mechanism. New methods of dispute resolution such as ADR facilitate parties to deal with the underlying issues in dispute in a more cost-effective manner and with increased efficacy. In addition, these processes have the advantage of providing parties with the opportunity to reduce hostility, regain a sense of control, gain acceptance of the outcome, resolve conflict in a peaceful manner, and achieve a greater sense of justice in each individual case. The resolution of disputes takes place usually in private and is more viable, economic, and efficient. ADR is generally classified into at least 4 types: negotiation, mediation, collaborative law, and arbitration. Sometimes a 5th type, conciliation, is included as well, but for present purposes it can be regarded as a form of mediation. Need of ADR in India. The system of dispensing justice in India has come under great stress for several reasons, mainly because of the huge pendency of cases in courts. In India, the number of cases filed in the courts has shown a tremendous increase in recent years, resulting in pendency and delays, underlining the need for alternative dispute resolution methods. It is in this context that a resolution was adopted by the Chief Ministers and the Chief Justices of States in a conference held in New Delhi on 4 December 1993 under the chairmanship of the then Prime Minister and presided over by the Chief Justice of India. It said, "The Chief Ministers and Chief Justices were of the opinion that courts were not in a position to bear the entire burden of justice system and that a number of disputes lent themselves to resolution by alternative modes such as arbitration, mediation and negotiation." They emphasized the desirability of disputants taking advantage of alternative dispute resolution, which provided procedural flexibility, saved valuable time and money, and avoided the stress of a conventional trial. In a developing country like India with major economic reforms underway within the framework of the rule of law, strategies for swifter resolution of disputes for lessening the burden on 1. the courts and to provide means for expeditious resolution of disputes, there is no better option but to strive to develop alternative modes of dispute resolution, ADR, by establishing facilities for providing settlement of disputes through arbitration, conciliation, mediation and negotiation. Impact resulting acts of ADR. The technique of ADR is an effort to design a workable and fair alternative to our traditional judicial system. It is a fast-track system of dispensing justice. There are various ADR techniques with arbitration, mediation, conciliation, mediation arbitration, mini-trial, private judging, final offer arbitration, court-annexed ADR and summary jury trial. These techniques have been developed on scientific lines in USA, UK, France, Canada, China, Japan, South Africa, Australia and Singapore. ADR has emerged as a significant movement in these countries and has not only helped reduce cost and time taken for resolution of disputes, but also in providing a congenial atmosphere and a less formal and less complicated forum for various types of disputes. The Arbitration Act, 1940 was not meeting the requirements of either the international or domestic standards of resolving disputes. Enormous delays and court intervention frustrated the very purpose of arbitration as a means for expeditious resolution of disputes. The Supreme Court in several cases repeatedly pointed out the need to change the law. The Public Accounts Committee too deprecated the Arbitration Act of 1940. In the conferences of Chief Justices, Chief Ministers and Law Ministers of all the states, it was decided that since the entire burden of justice system cannot be borne by the courts alone, an alternative dispute resolution system should be adopted. Trade and industry also demanded drastic changes in the 1940 Act. The Government of India thought it necessary to provide a new forum and procedure for resolving international and domestic disputes quickly. Thus, the Arbitration and Conciliation Act, 1996, came into being. The law relating to arbitration and conciliation is almost the same as in the advanced countries. Conciliation has been given statutory recognition as a means for settlement of the disputes in terms of this Act. In addition to this, the new Act also guarantees independence and impartiality of the arbitrators irrespective of their nationality. The new Act of 1996 brought in several changes to expedite the process of arbitration. This legislation has developed confidence among foreign parties interested to invest in India or to go for joint ventures, foreign investment, transfer of technology and foreign collaborations. The advantage of ADR is that it is more flexible and avoids seeking recourse to the courts. In conciliation mediation, parties are free to withdraw at any stage of time. It has been seen that resolution of disputes is quicker and cheaper through ADR. The parties involved in ADR do not develop strained relations, rather they maintain the continued relationship between themselves. Arbitration and Conciliation Act, 1996. Part I of this Act formalized the process of arbitration and Part 3 formalized the process of conciliation. Part 2 is about enforcement of foreign awards under New York and Geneva Conventions. Arbitration. The process of arbitration can start only if there exists a valid arbitration agreement between the parties prior to the emergence of the dispute. As per Section 7, such an agreement must be in writing. The contract, regarding which the dispute exists, must either contain an arbitration clause or must refer to a separate document signed by the parties containing the arbitration agreement. The existence of an arbitration agreement can also be inferred by written correspondence such as letters, telex, or telegrams which provide a record of the agreement. An exchange of statement of claim and defense in which the existence of an arbitration agreement is alleged by one party and not denied by other is also considered as valid written arbitration agreement. Any party to the dispute can start the process of appointing arbitrator, and if the other party does not cooperate, the party can approach the office of Chief Justice for appointment of an arbitrator. There are only two grounds upon which a party can challenge the appointment of an arbitrator: reasonable doubt in the impartiality of the arbitrator and the lack of proper qualification of the arbitrator as required by the arbitration agreement. A sole arbitrator or panels of arbitrators so appointed constitute the arbitration tribunal. Except for some interim measures, there is very little scope for judicial intervention in the arbitration process. The arbitration tribunal has jurisdiction over its own jurisdiction. Thus, if a party wants to challenge the jurisdiction of the arbitration tribunal, it can do so only before the tribunal itself. If the tribunal rejects the request, there is little the party can do except to approach a court after the tribunal makes an award. Section 34 provides certain grounds upon which a party can appeal to the principal civil court of original jurisdiction for setting aside the award. Once the period for filing an appeal for setting aside an award is over, or if such an appeal is rejected, the award is binding on the parties and is considered as a decree of the court. Conciliation. Conciliation is a less formal form of arbitration. This process does not require an existence of any prior agreement. Any party can request the other party to appoint a conciliator. One conciliator is preferred, but 2 or 3 are also allowed. In case of multiple conciliators, all must act jointly. If a party rejects an offer to conciliate, there can be no conciliation. Parties may submit statements to the conciliator describing the general nature of the dispute and the points at issue. Each party sends a copy of the statement to the other. The conciliator may request further details, may ask to meet the parties, or communicate with the parties orally or in writing. Parties may even submit suggestions for the settlement of the dispute to the conciliator. When it appears to the conciliator that elements of settlement exist, he may draw up the terms of settlement and send it to the parties for their acceptance. If both the parties sign the settlement document, it shall be final and binding on both. Note that in USA, this process is similar to mediation. However, in India, mediation is different from conciliation and is a completely informal type of ADR mechanism. Mediation. Mediation, a form of alternative dispute resolution, ADR, or appropriate dispute resolution, aims to assist 2 or more disputants in reaching an agreement. The parties themselves determine the conditions of any settlements reached, rather than accepting something imposed by a third party. The disputes may involve, as parties, states, organizations, communities, individuals or other representatives with a vested interest in the outcome. Mediators use appropriate techniques and/or skills to open and/or improve dialogue between disputants, aiming to help the parties reach an agreement, with concrete effects, on the disputed matter. Normally, all parties must view the mediator as impartial. Disputants may use mediation in a variety of disputes, such as commercial, legal, diplomatic, workplace, community and family matters. A third-party representative may contract and mediate between, say, unions and corporations. When a workers' union goes on strike, a dispute takes place, and the corporation hires a third party to intervene in attempt to settle a contract or agreement between the union and the corporation. Negotiation. Negotiation is a dialogue intended to resolve disputes, to produce an agreement upon courses of action, to bargain for individual or collective advantage, or to craft outcomes to satisfy various interests. It is the primary method of alternative dispute resolution. Negotiation occurs in business, non-profit organizations, government branches, legal proceedings, among nations and in personal situations such as marriage, divorce, parenting, and everyday life. The study of the subject is called negotiation theory. Those who work in negotiation professionally are called negotiators. Professional negotiators are often specialized, such as union negotiators, leverage buyout negotiators, peace negotiators, hostage negotiators, or may work under other titles, such as diplomats, legislators or brokers. Lok Adalat, while Arbitration and Conciliation Act, 1996 is a fairly standard Western approach towards ADR, The Lok Adalat system constituted under National Legal Services Authority Act, 1987 is a uniquely Indian approach. It roughly means, People's Court. India has had a long history of resolving disputes through the mediation of village elders. The system of Lok Adalats is an improvement on that and is based on Gandhian principles. This is a non-adversarial system, whereby mock courts, called Lok Adalats, are held by the state authority, district authority, Supreme Court Legal Services Committee, High Court Legal Services Committee, or Taluk Legal Services Committee, periodically for exercising such jurisdiction as they think fit. These are usually presided by retired judge, social activists, or members of legal profession. It does not have jurisdiction on matters related to non-compoundable offences. There is no court fee and no rigid procedural requirement, i.e. no need to follow process given by Civil Procedure Code or Evidence Act, which makes the process very fast. Parties can directly interact with the judge, which is not possible in regular courts. Cases that are pending in regular courts can be transferred to a Lok Adalat if both the parties agree. A case can also be transferred to a Lok Adalat if one party applies to the court and the court sees some chance of settlement after giving an opportunity of being heard to the other party. The focus in Lok Adalats is on compromise. When no compromise is reached, the matter goes back to the court. However, if a compromise is reached, an award is made and is binding on the parties. It is enforced as a decree of a civil court. An important aspect is that the award is final and cannot be appealed, not even under Article 226 because it is a judgment by consent. All proceedings of a Lok Adalat are deemed to be judicial proceedings and every Lok Adalat is deemed to be a civil court. Lok Adalat, People's Courts, established by the government, settles dispute through conciliation and compromise. The first Lok Adalat was held in Chennai in 1986. Lok Adalat accepts the cases which could be settled by conciliation and compromise and pending in the regular courts within their jurisdiction. The Lok Adalat is presided over by a sitting or retired judicial officer as the chairman, with two other members, usually a lawyer and a social worker. There is no court fee. If the case is already filed in the regular court, the fee paid will be refunded if the dispute is settled at the Lok Adalat. The procedural laws and the Evidence Act are not strictly followed while assessing the merits of the claim by the Lok Adalat. Main condition of the Lok Adalat is that both parties in dispute should agree for settlement. The decision of the Lok Adalat is binding on the parties to the dispute and its order is capable of execution through legal process. No appeal lies against the order of the Lok Adalat. Lok Adalat is very effective in settlement of money claims. Disputes like partition suits, damages and matrimonial cases can also be easily settled before Lok Adalat as the scope for compromise through an approach of give and take is high in these cases. Lok Adalat is a boon to the litigant public, where they can get their disputes settled fast and free of cost. Question: Explain Bangalore Principles. The Bangalore Principles of Judicial Conduct. The group recognized at the outset the need for a universally acceptable statement of principles of judicial conduct. Such a statement would explain aspects of appropriate conduct to judges, encourage informed public understanding of the judicial system, and inspire public confidence in the integrity of the judiciary. An initial draft based on a survey of existing national codes in common law countries was prepared by the coordinator. At its second meeting held in Bangalore, the group agreed upon the text of the document that came to be known as the Draft Bangalore Code of Judicial Conduct. Over the next 20 months, the Bangalore draft was widely disseminated among senior judges of both common law and civil law systems, and discussed at several conferences at which chief justices and other senior justices were present. On the initiative of the American Bar Association's Keeley offices, the Bangalore draft was translated into the national languages of Albania, Bosnia and Herzegovina, Bulgaria, Croatia, Kosovo, Romania, Serbia and Slovakia, and then reviewed by judges associations and constitutional and supreme courts of these countries. A significant contribution towards its evolving form was made by the Consultative Council of European Judges. That body, which functioned within the Council of Europe and represented at that time the judicial systems of 30 European countries, commissioned an expert study of the Bangalore draft. Thereafter, at a meeting to which the coordinator of the group and the UN Special Rapporteur on the independence of judges and lawyers were invited, it conducted a full and frank discussion from the perspective of the civil law system, and then adopted a comprehensive report on specific provisions of the draft. In the light of the comments and criticisms received and in order to ensure that the final document faithfully reflected the position of civil law jurisdictions, the Bangalore draft was revised and placed before a roundtable meeting of Chief Justices drawing principally from the civil law system, which was held at the Peace Palace at The Hague. Several judges of the International Court of Justice also participated at this meeting. The final draft that emerged from this meeting, the Bangalore Principles of Judicial Conduct, was translated into Russian, Chinese, French, Spanish and Arabic and annexed to the report presented to the 59th session of the Commission on Human Rights in April 2003 by the UN Special Rapporteur on the Independence of Judges and Lawyers. The Commission, by a resolution adopted without dissent, noted the Bangalore Principles of Judicial Conduct and brought those principles to the attention of member states, the relevant United Nations organs and intergovernmental and non-governmental organizations for their consideration. In July 2006, the Economic and Social Council of the United Nations, ECOSOC, adopted a resolution recommended to it by the UN Commission on Crime Prevention and Criminal Justice, in which it recognized the Bangalore Principles of Judicial Conduct as representing a further development of, and as being complementary to, the UN Basic Principles on the Independence of the Judiciary 1985. Accordingly, ECOSOC invited member states to encourage their judiciaries to take into consideration the Bangalore Principles when reviewing or developing rules with respect to the professional and ethical conduct of members of the judiciary. ECOSOC also invited member states to submit to the UN Secretary-General their views regarding the Bangalore Principles and to suggest revisions, as appropriate. 14 member states submitted their views concerning the Bangalore Principles of Judicial Conduct. In March 2007, in his report to ECOSOC, the UN Secretary-General noted as follows: all of the responding states welcomed the Bangalore Principles as a useful basis for the development of domestic standards and rules governing the professional conduct of judges. Many states regarded the guidance contained in the principles as a valuable tool for strengthening the independence, impartiality, integrity, propriety, competence and diligence of judges, as well as to ensure equality of treatment for all before the courts. 10 of the responding states informed the UN Secretary-General that their judiciaries had already adopted standards and rules that complied with the values and guidelines enshrined in the Bangalore Principles, while 4 reported that they were in the process of reviewing existing professional standards and rules of judicial conduct in the light of the Bangalore principles. As mandated by ECOSOC, the comments submitted by member states were placed before an open-ended intergovernmental group of experts convened by the United Nations Office on Drugs and Crime, UNODC, in Vienna in February 2007. The Secretary-General's report added that, having considered the proposed amendments, the participants were of the view that, since the text of the principles had only recently been endorsed by ECOSOC, it was premature to consider amending it. In addition, as most of the comments were aimed at clarifying and developing the values and guidelines already contained in the principles rather than raising new points, it was felt that it would be more appropriate to insert these comments in the commentary rather than in the text of the principles itself. In July 2007, ECOSOC adopted a further resolution recommended to it by the UN Commission on Crime Prevention and Criminal Justice, in which it noted with appreciation the report of the Secretary-General on strengthening basic principles of judicial conduct, in particular the progress reported by several member states on the implementation of the Bangalore Principles of Judicial Conduct, and invited member states, consistent with their domestic legal systems, to continue to encourage their judiciaries to take into consideration the Bangalore Principles of Judicial Conduct when reviewing or developing rules with respect to the professional and ethical conduct of members of the judiciary. Question: examine the tools and techniques of judicial creativity and precedent. 1. The tools and techniques of judicial creativity and precedent. Uttarakhand Jain Morcha, AIR 1999, Supreme Court 2193. The Supreme Court has imposed restriction on judicial creativity, saying that, no doubt, role of the judiciary has been expanded to newer dimensions in recent past, but that is no justification for using judicial power for imposing such unbearable burden on the state, which in turn would be compelled to extract money out of common man's coffers to meet such massive financial burden. Suffice it to say that the above direction issued by the High Court cannot stand judicial scrutiny, and it is hereby set aside. Often a question arose for discussion that whether the judges are as competent as the legislators to mete out the needs, requirements and aspirations of the people. Judges have limited scope in lawmaking. In this respect, 3 things need to be kept in mind. Firstly, if the judges are considered sufficiently qualified to correctly decide upon the morality of the people, then there is no reason to consider them incompetent to gauge the needs of the people in lawmaking. Secondly, how much effort do the legislators actually expend in understanding the true needs of the people and the social implications of the law? It is not unknown that nowadays bureaucrats prepare draft of the proposed legislation and without any serious discussion in the House, same are passed as usual. Thirdly, judges rarely create a law from scratch. Their legislative role is largely restricted to filling up the gaps in the law. The judge is not to innovate at pleasure. He is not a knight-errant roaming at will in pursuit of his own ideal of beauty or of goodness. Cardozo, The Nature of the Judicial Process. Further, he went on to say that, he is to draw his inspiration from settled principles. He is not to yield to spasmodic sentiment, to vague and unregulated benevolence. He is to exercise a discretion informed by tradition, methodized by analogy, disciplined by system, and subordinated to promotional necessity of order in the social life. According to Cardozo, the great generalities of the Constitution, and the content of which has been and continues to be supplied by courts from time to time. He had further opined that constitutional provisions which have a content and a significance that vary from age to age. Benjamin Cardozo opined that in Bengal Immunity Company Limited v State of Bihar, AIR 1955 SC 661, the Supreme Court has observed that it was not bound by its earlier judgments and possessed the freedom to overrule its judgments when it thought fit to do so to keep pace with the needs of changing times. The acceptance of this principle ensured the preservation and legitimation provided to the doctrine of binding precedent, and therefore, certainty and finality in the law, while permitting necessary scope for judicial creativity and adaptability of the law to the changing demands of society. There is no law on social disorder called sexual harassment of a woman at workplace. The Apex Court in Visakhapatnam v State of Rajasthan, AIR 1977 SC 3011, created law of the land observing that the right to be free from sexual harassment is a fundamental right under Articles 14, 15 and 21 of the Constitution. It has been 10 years since the Honble Supreme Court issued Visakhapatnam guidelines regarding sexual harassments, but still a draft bill on the subject is waiting for enactment. As per these guidelines, every organization, whether government or public, is to have an internal complaints committee to investigate complaints regarding sexual harassment at workplace. A code of conduct is prepared for all employees and that should be incorporated in the service rules standing instructions. Sexual harassment at workplace is a criminal offense and the accused would face civil as well as criminal liabilities. Articles 141 and 142 to point out that they are couched in such wide and elastic terms as to enable the Supreme Court to formulate legal doctrines to meet the ends of justice. The only limitation therein is reason, restraint and injustice. These articles are designedly made comprehensive to enable the Supreme Court to declare law and to give such direction or pass such order as is necessary to do complete justice. This is a powerful instrument of justice placed in the hands of the highest judiciary of our country. Former CJI Anand observed that the Apex Court has given purposive, liberal and creative interpretation of Article 21 of the Constitution by giving it more content, meaning and purpose. In expanding the ambit of right to life and personal liberty, the court has evolved tools and techniques of compensatory jurisprudence, implemented international conventions and treaties, and issued directions for environmental justice. Law must keep pace with society to retain its relevance, therefore, judicial creativity is necessary for meeting with the ends of justice. The theory of basic structure of the Constitution is a result of the creative interpretation of the Supreme Court. Union of India, AIR 2007 Supreme Court 71, the Apex Court has held that this development is the emergence of the constitutional principles in their own right. It is not based on literal wordings. These principles are part of constitutional law even if they are not expressly stated in the form of rules. An instance is the principle of reasonableness which connects Arts 14, 19 and 21. Some of these principles may be so important and fundamental as to qualify as essential features or part of the basic structure of the Constitution, that is to say, they are not open to amendment. Right to livelihood, right to go abroad, right to privacy, right against solitary confinement, right to shelter, right to legal aid and speedy trial, right against bar fetters, right against handcuffing, right against delayed execution, right against custodial violence, right to doctor's assistance, right to water, right to food, right to clean air and healthy environment, right to pollution-free water, right to free education up to the age of 14 years, and right of every child to full development, right against illegal arrest, are all indeed judicial creativity and the result of the creative interpretation. In State of T.N. Abu Kavur by AIR 1984 Supreme Court 326, it was held that on a careful consideration of the legal and historical aspects of the directive principles and the fundamental rights, there appears to be complete unanimity of judicial opinion of the various decisions of the Supreme Court on the point that although the directive principles are not enforceable, yet the court should make a real attempt at harmonizing and reconciling the directive principles and the fundamental rights. Reading fundamental rights in the directive principles is a technique of judicial creativity. For the first time, the right to know about the candidate standing for election has been brought within the sweep of Art. 19(1)(a) by the Supreme Court through its creative interpretation. The apex court in People's Union for Civil Liberties, PUGL, v. Union of India, AIR 2003 Supreme Court 2363, has held that voters' right to know about the antecedents of the candidate contesting for the election falls within the realm of freedom of speech and expression guaranteed by Art. 19(1)(a), and can be justified on good and substantial grounds. In Balco Employees Union, Red, v. Union of India, AIR 2002 Supreme Court 350, the apex court has cautioned that there are some of the dangers in public interest litigation which the court has to be careful to avoid. It is also necessary for the court to bear in mind that there is a vital distinction between locus standi and justifiability, and it is not every default on the part of the state or a public authority that is justiciable. The court must take care to see that it does not overstep the limits of its judicial function and trespass into areas which are reserved to the executive and the legislature by the Constitution. It is a fascinating exercise for the court to deal with public interest litigation because it is a new jurisprudence which the court is evolving, a jurisprudence which demands judicial statesmanship and high creative ability. In State of Bihar v. Balmukund, AIR 2000 Supreme Court 1296, the Supreme Court has emphasized its creative role in achieving the goal of socio-economic justice. The judiciary has, therefore, a socio-economic destination and a creative function. It has to use the words of G. Austin, to become an arm of the socio-economic revolution and perform an active role calculated to bring social justice within the reach of the common man. It cannot remain content to act merely as an umpire, but it must be functionally involved in the goal of socio-economic justice. The entitlement of the accused to speedy trial has been repeatedly emphasized by the Supreme Court. Though it is not enumerated as a fundamental right in the Constitution, the apex court has recognized the same to be implicit in the spectrum of Article 21. In Hossanara Khatun v. Home Secretary, State of Bihar, AIR 1979 SC 1360, the court, while dealing with the cases of under-trials, who had suffered long incarceration, held that a procedure which keeps such large number of people behind bars without trial so long cannot possibly be regarded as reasonable, just or fair so as to be in conformity with the requirement of Article 21. The court laid stress upon the need for enactment of law to ensure reasonable, just and fair procedure, which has creative connotation after Maneka Gandhi's case, 1978, 1 SCC 248 in the matter of criminal trials. In Municipal Corporation of Greater Bombay v Indian Oil Corporation Limited AIR 1991 Supreme Court 686, has held that keeping in view the social, economic and political goal setting in which it is intended to operate, judge is called upon to perform a creative function. He has to inject flesh and blood in the dry skeleton provided by the legislature and by a process of creative interpretation, invest it with a meaning which will harmonize the law with the prevailing concepts and values and make it an effective instrument for delivering justice. In Delhi Transport Corporation v Mazdoor Congress, AIR 1991 SC 101, Sabyasachi Mukherjee, former CJI, said that I am definitely of the opinion that time has come for the judicial interpretation to play far more active, creative and purposeful role in deciding what is according to law. I believe that we must do away with the childish fiction that law is not made by the judiciary. Austin in his jurisprudence, 4th edition, has described the Blackstone's principle of finding the law as the childish fiction. Chief Justice K. Subba Rao in L. Golaknath v State of Punjab, AIR 1967 SC 1643 at p. 1667, has referred to these observations. The Supreme Court under Art. 141 of the Constitution is enjoined to declare law. The expression, declared, is wider than the words, found or made. To declare is to announce opinion. Indeed, the latter involves the process, while the former expresses result. Interpretation, ascertainment and evolution are parts of the process, while that interpreted, ascertained or evolved is declared as law. The law declared by the Supreme Court is the law of the land. To deny this power to the Supreme Court on the basis of some outmoded theory that the court only finds law but does not make it, is to make ineffective the powerful instrument of justice placed in the hands of the highest judiciary of this country. I would, therefore, plead for a more active and creative role for the courts in declaring what the law is. Great artistry and skill is needed to fill in the gaps because Acts of Parliament were not drafted with divine prescience and perfect clarity. It is not possible for the legislators to foresee the manifold sets of facts and controversies which may arise while giving effect to a particular provision. Indeed, the legislators do not deal with the specific controversies. When conflicting interests arise or defect appears from the language of the statute, the court by consideration of the legislative intent must supplement the written word with force and life. See the observation of Lord Denning in Seaford Estate Limited Ashaya, 1949, 2 kilobyte 481 at p. In Sher Singh v State of Punjab, 1983, 2 SCR 582. The Apex Court explained that the horizons of Article 21 are ever widening and the final word on its conspectus shall never have been said. So long as life lasts, so long shall it be the duty and endeavor of this court to give to the provisions of our Constitution a meaning which will prevent human suffering and degradation. Therefore, Article 21 is as much relevant at the stage of execution of the death sentence as it is in the interregnum between the imposition of that sentence and its execution. The essence of the matter is that all procedure, no matter the stage, must be fair, just and reasonable. Article 21 thus received a creative connotation. The Supreme Court in Jagdambika Pratap Narayan Singh v Central Board of Direct Taxes, AIR 1975 SC 1816, dealing with the question of limitation in granting a relief, has observed that any legal system, especially one evolving in a developing country, might permit judges to play a creative role and innovate to ensure justice without doing violence to the norms set by legislation. The role of the court is creative rather than passive, and it assumes a more positive attitude in determining facts and circumstances of each case. Justice Cardozo approvingly quoted President T. Roosevelt's stress on the social philosophy of the judges, which shakes and shapes the course of a nation and, therefore, the choice of judges for the higher courts which makes and declares the law of the land, must be in tune with the social philosophy of the Constitution. Not mastery of the law alone, but social vision and creative craftsmanship are important inputs in successful justicing. One as quoted in S. President of India, AIR 1982 SC 149. Creativity in Maneka Gandhi's case is clearly visible when the Supreme Court has took the view that Article 21 affords protection not only against executive action but also against legislation, and any law which deprives a person of his life or personal liberty would be invalid unless it prescribes a procedure for such deprivation which is reasonable, fair and just. The concept of reasonableness, it was held, runs through the entire fabric of the Constitution, and it is not enough for the law merely to provide some semblance of a procedure, but the procedure for depriving a person of his life or personal liberty must be reasonable, fair and just. 1. Maneka Gandhi v Union of India, AIR 1978 SC 597. Legislating, exactly in the way in which a legislature legislates, and he observes by reference to a few cases that the guidelines laid down by court, at times, cross the border of judicial lawmaking in the realist sense and trench upon legislating like a legislature. Directions are either issued to fill in the gaps in the legislation or to provide for matters that have not been provided by any legislation. Statute has to be interpreted as a whole and with reference to specific context in question. If it appears to the court any gap in the legislation, unmerited prejudice and hardship have been caused to the citizens, the court may have to depend on its own creativity so that hardship is not meted out to the people. Professor S.P. Sathe, in his work, year 2002, Judicial Activism in India, Transgressing Borders and Enforcing Limits, touches the topic, Directions, a new form of judicial legislation, evaluating legitimacy of judicial activism. The learned author has cautioned against courts not to cross the border in the name of creativity. The court has taken over the legislative function not in the traditional interstitial sense but in an overt manner, and has justified it as being an essential component of its role as a constitutional court. P. 242. In Delhi Transport Corporation v. Mazdoor Congress, AIR 1991 Supreme Court 101, it is true that judicial jealousy of legislature in lawmaking has long been outdrawn, but the strict construction remains still an established rule. It is generally accepted principle that judges in interpreting statutes should give effect to the legislator's intent. By doing so, the courts do recognize their subordinate position and their obligation to help the legislature to achieve its purpose. But in that effort, creativity is essential. In State of Gujarat v Mirzapur Moti Qureshi Ka Sab Jamaat, AIR 2006 Supreme Court 212, the Apex Court has held that post-Keswananda Bhati, so far as the determination of the position of directive principles, vis-à-vis fundamental rights are concerned, it has been an era of positivism and creativity. Article 37 of the Constitution, which while declaring the directive principles to be unenforceable by any court, but in case Swananda Bharti v. State of Kerala, AIR 1973 SC 1461, court goes on to say that they are nevertheless fundamental in the governance of the country. The end part of Article 37, it shall be the duty of the state to apply these principles in making laws, is not a pariah but a constitutional mandate. Supreme Court has held that, while interpreting the interplay of rights and restrictions, Part 3, Fundamental Rights, and Part 4, Directive Principles, have to be read together. On the basis of the above discussion, it is clear that judicial creativity is not only necessary but also inevitable. The only thing is to keep in mind that judicial creativity is permissible only in the area left open by the legislature and where it is necessary to fill up the gap in the statute so as to achieve real intent of it. If law is available on the subject, then judicial creativity must be restricted to interstitial creation of law, otherwise it would become judicial excess in the domain of legislature. A judge can discharge his creative role only when he has acquired sufficient knowledge, tools and techniques and interpretive skill of judicial creativity. Alternative dispute resolution, ADR, known in some countries, such as India, as external dispute resolution, includes processes and techniques that act as a means for disagreeing parties to come to an agreement short of. It is a collective term for the ways that parties can settle disputes, with the help of a third party. Despite historic resistance to ADR by many popular parties and their advocates, ADR has gained widespread acceptance among both the general public and in recent years. In fact, some courts now require some parties to resort to ADR of some type, usually, before permitting the parties' cases to be tried. Indeed, the 2008 expressly contemplates so-called compulsory mediation. This means that attendance is compulsory, not that settlement must be reached through mediation. Additionally, parties to transactions are increasingly turning to ADR to resolve post-acquisition disputes. The rising popularity of ADR can be explained by the increasing caseload of traditional courts, the perception that ADR imposes fewer costs than litigation, a preference for confidentiality, and the desire of some parties to have greater control over the selection of the individual or individuals who will decide their dispute. Some of the senior judiciary in certain jurisdictions, of which England and Wales is one, are strongly in favor of this ADR use of mediation to settle disputes. Contents. Salient features. Alternative dispute resolution, ADR, is generally classified into at least 4 types. Sometimes, is included as a 5th category, but for simplicity may be regarded as a form of. ADR can be used alongside existing legal systems such as courts within common law jurisdictions, such as the UK. ADR traditions vary somewhat by country and culture. There are significant common elements which justify a main topic, and each country or region's difference should be delegated to subpages. ADR is of 2 historic types. First, methods for resolving disputes outside of the official judicial mechanisms. Second, informal methods attached to or pendant to official judicial mechanisms. There are in addition freestanding and/or independent methods, such as mediation programs and ombuds offices within organizations. The methods are similar, whether or not they are pendant, and generally use similar tool or skill sets, which are basically subsets of the skills of negotiation. ADR includes informal tribunals, informal mediative processes, formal tribunals and formal mediative processes. The classic formal tribunal forms of ADR are arbitration, both binding and advisory or non-binding, and private judges, either sitting alone, on panels or over summary jury trials. The classic formal mediative process is referral for mediation before a court-appointed mediator or mediation panel. Structured transformative mediation as used by the U.S. Postal Service is a formal process. Classic informal methods include social processes, referrals to non-formal authorities, such as a respected member of a trade or social group, and intercession. The major differences between formal and informal processes are a. Pendency to a court procedure and b. The possession or lack of a formal structure for the application of the procedure. For example, free-form negotiation is merely the use of the tools without any process. Question: explain judge-made law and judge-declared law. In 1345, an English lawyer argued to the court, "I think you will do as others have done in the same case, or else we do not know what the law is." "It is the will of the justices," said Judge Hillary. Chief Justice Stonor broke in, "No, law is that which is right." This controversy between the two judges is still raging after 6.5 centuries. In modern terms, the problem can be phrased in order to know exactly what part do judges play in the development of law. Do judges make or declare law? Argument to this paper concentrates on the belief that in hard cases, judges can and do create new law. In the paper, it seems that there are clear indications that judges do indeed create new law where, for example, existing laws have become outdated or inappropriate. This thesis essentially stems from the views of the famous common law theorist, Hart, a legal positivist who sees the fusion of primary and secondary rules as being the determinant of what later becomes known as a legal system. But another thinker, Dworkin, is vehemently against the law-making power of the judges. For him, there is no law beyond the law. The law is a seamless web in which there will always be a right answer. This paper will analyze the philosophical Hart-Dworkin debate on adjudication, taking Raj also with them, and then apply it to the practical life in the Indian context to conclude that judges make law out of what they discover in the legal field. This paper will proceed to answer two questions. 1. Is it possible to reach on a consensus on judges' role through a philosophical way? 2. Assuming that judges don't make law, then is it always possible to declare law? First question. How do judges make law? What opportunities do judges have to be creative? These are the questions which the philosophers have in the back of their mind while talking about the judge's role during adjudication. It is said that judges make new law or so-called creative especially in two fields. 1. In the development of the common law and 2. In the interpretation of statutes. Nevertheless, their freedom is restricted by the rules of precedent and the supremacy of parliament and by the rules of precedent and the rules of statutory interpretation. Judicial precedent. The application of precedent by judges, whether they are developing the common law, for e.g. in areas such as negligence or murder, or interpreting statutes, is the main mechanism whereby judges make law. Occasionally, judges are called upon to give a ruling or make a decision when faced with a situation for which there seems to be no precedent or any guiding rule. In these circumstances, judges can be said to be formulating original precedent. Thus, it is the judge's role to use his own discretion regarding when he thinks rules need to be applied, changed, improved, or abolished. For this reason, Although Hart sees the function of law as being one of a system of rules, he maintains a firm belief that where there are gaps in the system, judges should use their own discretion when applying the law. Hart believes that because statutes and common law rules are often too vague and unclear, it is often inevitable in hard cases for a judge to create new law. He talks about the open texture of law means that are, indeed, areas of conduct where courts or officials striking a balance, in the light of circumstances, between competing interests, which vary in weight from case to case, must leave much to be developed. But according to Dworkin, principles are essential elements in deciding these types of hard cases. He seeks to argue that in all cases a structure of legal principles stands behind and informs the applicable rules. Principles control the interpretation of rules. Rules derive their meaning from principles. Judges, through the rules of precedent, merely discover and declare the existing law and never make new law. A judge makes a decision, not according to his own private judgment, but according to the known laws and customs of the land, not delegated to pronounce a new law, but to maintain and expound the old one. He is against the judge-made law mainly because of two objections. The first argues that elected representatives who are responsible to the people should govern a community, and when judges make law it will be an encroachment on legislative power. The second argues that if a judge makes new law and applies it retroactively in the case before him, then the losing party will be punished, not because he violated some duty he had, but rather a new duty created after the event. Countering Dworkin's first argument, Hart says that judges' power is subject to many constraints narrowing his choice, and judges' power are exercised only to dispose of particular instant cases. He cannot use these to introduce large-scale reforms or new codes. Even though if they make new law, it is in accordance with principles or underpinning reasons recognized as already have a footing in the existing law. This indeed is the very nucleus of the constructive interpretation, which is so prominent feature of Dworkin's theory of adjudication. Dworkin also talks about the discretion, but for him judges' choices are within the constraints of judgment, which he called as weak discretion. Dworkin does not deny the need for weak discretion, but he denies the existence of strong judicial discretion. Judges do not make law because the existing law provides all the resources for their decisions. A judge does not decide a case in a legal vacuum but on the basis of existing rules, which express, and, at the same time, are informed by, underlying legal principles. The task of the judge faced with a hard case is, therefore, to understand what decision is required by the whole doctrinal structure of existing law. Regarding Dworkin's second criticism, Hart says that this objection seems quite irrelevant in hard cases since these are cases which the law has left incompletely regulated, and where there is no known state of clear established law to justify expectations. It's true that in every legal system, a large and important field is left open for the exercise of discretion by courts in rendering initially vague standards determinate, in resolving the uncertainties of statutes, or in developing and qualifying rules only broadly communicated by authoritative precedents. Nonetheless, these activities, important and insufficiently studied though they are, must not disguise the fact that both the framework within which they take place and their chief end product is one of general rules. These are rules the application of which individuals can see for themselves in case after case, without further recourse to official direction or discretion. According to Hart, law in the area of open texture is a guarded prediction of what the courts will do. Even if the rules are clear to all, the statement of it may often be made in the form of a prediction of the court's decision. But the important thing to be noted here is that the basis for such prediction is the knowledge that the courts regard legal rules not as predictions, but as standards to be followed in decision, determinate enough, in spite of their open texture, to limit, though not to exclude, their discretion. Judges do not generally, when legal rules fail to determine a unique result, intrude their personal preferences or blindly choose among alternatives, and when words like choice and discretion, or phrases such as creative activity and interstitial legislation are used to describe decisions, these do not mean that courts do decide arbitrarily without elaborating reasons for their decisions. And in case if there is any arbitrariness, then legislature is always there to negate it down. According to Raj, also, courts do develop the law, they do not as political agents but by working out the implications of internal legal considerations. Courts in developing the law do not give expression to their personal views, nor do they reflect external social or political forces. Rather, they unravel the spirit of the law, unfold its hidden force and reveal its meaning. He says that judges can make the law even when precedent binds them by distinguishing it with the previous decision, but this is very restricted form of lawmaking subjected to two crucial conditions. Firstly, the modified rule must be the rule laid down in the precedent restricted by the addition of a further condition for its application, and secondly, the modified rule must be such as to justify the order made in the precedent. The judge's obligation is to adopt only that modification which will best improve the rule. In the exercise of their lawmaking power, the courts should within the legally imposed restrictions act by adopting the best rules they can find. They may make a new rule in a decision, which he thinks is a purely law-applying decision. Thus, on the basis of the above debate, discussion can be boiled down to the point that judges declare the law, and the question of their making law can be defended by saying that their invention is merely discovery of law within the existing precedents and principles. Limited choice cannot be termed as absolute power, it is just a weak discretion, as Dworkin will say it, constrained with certain limitations. Heart's open texture of law is also not enjoying the freedom from legal constraints, they have to also take guidance from the legal rules, considering them their standard. Same with Raj too. But is it always possible to declare law, taking into consideration about our practical life situation? This leads us to our second question. Second question. I believe that we must do away with the childish fiction that law is not made by the judiciary. Sabyasachi Mukherjee, C.J. In C. Ravichandran Iyer v. Justice A.M. Bhattacharjee, the court said that the role of the judge is not merely to interpret the law but also to lay new norms of law and to mold the law to suit the changing social and economic scenario, to make the ideals enshrined in the Constitution meaningful and a reality. The society demands active judicial roles which formerly were considered exceptional but now a routine. In S. P. Gupta v. President of India, the court observed, the interpretation of every statutory provision must keep pace with changing concepts and values, and it must, to the extent to which its language permits or rather does not prohibit, suffer adjustments through judicial interpretation so as to accord with the requirements of the fast-changing society which is undergoing rapid social and economic transformation. The court also went on to say that law does not operate in a vacuum. It is therefore intended to serve a social purpose, and it cannot be interpreted without taking into account the social, economic and political setting in which it is intended to operate. It is here that the judge is called upon to perform a creative function. He has to inject flesh and blood in the dry skeleton provided by the legislature and by a process of dynamic interpretation, invest it with a meaning which will harmonize the law with the prevailing concepts and values and make it an effective instrument for delivery of justice. It is clear from the above statements that, not only constitutional interpretation, but also statutes have to be interpreted with the changing times, and it is here that the creative role of the judge appears. Thus the judge clearly contributes to the process of legal development. The courts do not always follow the precedent blindly and do not always consider themselves bound by the given principles. The court does evolve new principles. However, the courts do always have to follow within the limits of the Constitution, and they cannot exceed the constitutional limits. When new societal conditions and factual situations demand the judges to speak, they, without professing the tradition of judicial lockjaw, must speak out. Also, in MC Mehta v Union of India, Shri Ram, Oleum Gas, the court said that with the development and fast-changing society the law cannot remain static and that the law has to develop its own new principles. The above decision reflects that the courts do make law, they frame new principles, interpret the statutes and the constitution with the changing times. Question: explain relations between law and justice. Difference between law and justice. The concepts of law and justice are often confused and misinterpreted by many. While the two are strictly connected, they are not the same thing. Justice is a broad concept that is based on equality of rights, fairness and morality. Conversely, law is a body of regulations and standards set up by governments and international bodies and is, or should be, based on the idea of justice. Laws are written norms that regulate the actions of the citizens and of the government itself in all aspects, whereas justice is a principle that may or may not be universally recognized. What is law? Laws are rules and guidelines established and enforced by the government and its entities. They vary from country to country, and there is a body of international laws that applied to all states that decide to ratify certain treaties or conventions. National laws are principles and norms that regulate the behavior of all citizens and of all individuals under the government's jurisdiction. Laws are created by the government through a long and complex process, and once established they are implemented by governmental entities and interpreted by lawyers and judges. Laws establish what citizens, business, and governmental agencies can or cannot do. Although there is a set of written legislations, the judiciary system has the power to interpret them and to enforce them in all different situations. Laws vary from one country to another, or even from one state to another in the United States. That is why lawyers can only operate in the country where they passed the national exam. What is justice? Justice is a broad and somehow abstract concept based on equality of rights, fairness, kindness, dignity, moral and ethics. In a just world, we would not have discrimination, violence, abuses, poverty, slavery, and injustices in general. Therefore, all laws should be based on the idea of justice, and all governments should enforce national laws in a just and equal way. Unfortunately, this is not always the case, and laws are often broken, non-respected and/or enforced in biased and partial ways. Furthermore, justice supersedes national legislation and applies to all individuals without discriminations or limitations. Similarities between law and justice. The concepts of law and justice are fairly similar, as most laws are thought to be just and fair. Some of the main similarities between the two include: 1. Both concepts regulate human behavior and aim at creating a more just and equal environment. 2. Law should be based on the idea of justice and should be implemented and interpreted in a just manner without discriminations. And 3. Both are based on the ideas of morality, equality, order, and fairness. Difference between law and justice. Although the two concepts are strictly linked, there are key differences that cannot be overlooked. 1. The term law refers to an existing and concrete set of written regulations established by the government in order to regulate and control the actions of the citizens. Conversely, justice is not a universally recognized concept and is subject to interpretations. Justice is often depicted a woman wearing a blindfold representing equality and fairness, and applying laws and regulations to all individuals without discrimination. Yet, there is no common understanding of justice and there is no unique book or text to refer to, and 2. Laws can vary from country to country and the process with which they are created can change as well. For instance, in democratic countries, laws are adopted following a long debate and an even longer process of checks and balances. Conversely, in authoritarian countries, laws are decided and established by the ruling party, or by the ruling person, without seeking the support of the majority. Conversely, the idea of justice is more or less consistent across all countries. Moral values and ethics tend to supersede borders and geographic divisions. Law versus justice. Building on the differences outlined in the previous section, we can identify few other aspects that differentiate law from justice. Difference between law and justice. Comparison table. Law. Justice. Implementation. Laws apply within one country and to all individuals under the government's jurisdiction. Furthermore, international law applies to all countries that ratify certain covenants or treaties. National laws are enforced by the government and its bodies, police, judiciary, etc., while international law is enforced by international organizations and tribunals. Justice is the underlying principle upon which all laws should be based. Yet, there is no implementation of justice as such, but laws and norms can be implemented and enforced in a just and fair way by judges, governments, lawyers, and international bodies. Creation. Laws are created by politicians through a long process of checks and balances and can be approved, or not, by the country's population. The creation of a law follows a different process depending on the country, and can last few days or even months. Justice is not created, it is a broad concept that unites universal ethical and moral standards. Although it is not universally recognized, the idea of justice is based on values and principles that are intrinsic to the human nature. Summary of law and justice. The terms law and justice refer to two similar yet different concepts. The ideas of law and justice often go hand in hand but refer to two different ideas. Law is a system of regulations, standards, principles and norms created by a country's government in order to regulate the life and the actions of the citizens. Laws are found in written codes and are enforced by the government and its bodies, including security forces, police, judiciary, etc. Conversely, justice is a more abstract concept based on the idea of equality of rights and fairness. All laws should be based on the idea of justice and should be implemented and enforced in a just way without discrimination of sex, gender, age, color, race, religion, language or any other status. Question: is judicial process an instrument of social ordering. Judicial process, an instrument of social ordering. Introduction. Judicial process means any judicial proceeding in connection with the dispensation of justice by any court of competent jurisdiction, and social ordering means activating the instrument of judicial process in setting right the wrong done or eliminating injustice from the society. But here we are mainly concerned with role of the constitutional courts evolving new juristic principles during the course of judicial process for upholding social order, keeping in view the need of fast changing society. Therefore, it would be appropriate to examine as to whether judicial process is an instrument of social ordering. Article 32, Instrument of Social Ordering. Article 32 of the Constitution empowers the Supreme Court to issue directions or orders or writs for enforcement of any right conferred under the Constitution for securing social justice. The Supreme Court has granted great relief in cases of social injustice to the affected groups of the society under this provision. Article 32 is an important instrument of judicial process to enforce social ordering. Article 32 of the Constitution of India itself is a fundamental right, which accorded free hand to the judicial process, enabled the Supreme Court to take suitable action for the enforcement of social order. Deprivation of the fundamental rights often results into social disorder. The Supreme Court is a sentinel of all fundamental rights, and we are satisfied to see that the Apex Court has taken recourse of judicial process effectively in every area of social disorder to set it right and granted relief for each type of evil prevailing in the society. The Supreme Court has played positive role in implementing social order. Now it will be appropriate to examine the areas in which judicial process played a vital role in eliminating social disorder. Backward classes of the society in Indra Sohni v. Union of India, AIR 1993, Supreme Court 477, the Apex Court has innovated concept of creamy layer test for securing benefit of social justice to the backward class, needy people, and excluded persons belonging to creamy layer. Bigamy. Bigamy is a social evil which often creates social disorder. The Apex Court has tightened the noose over those avoiding punishment by taking plea of conversion to Islam. In Lily Thomas v. Union of India, AIR 2000 SC 1650, it was held by the Apex Court that the second marriage of a Hindu husband after conversion to Islam without having his first marriage dissolved under law would be invalid. The second marriage would be void in terms of the provisions of Section 494 IPC, and the apostate husband would be guilty of the offence punishable under Section 494 IPC. This verdict of the Apex Court would certainly be helpful in eliminating social evil of bigamy. Bride burning. In Paniben v. State of Gujarat, AIR 1992 SC 1817, the Apex Court held that it would be a travesty of justice if sympathy is shown when cruel act like bride burning is committed. Undue sympathy would be harmful to the cause of justice. The Apex Court directed that in such cases heavy punishment should be awarded. Bonded labourers. Bandhua Mukti Morcha v. Union of India, AIR 1984 SC 802, is a good example of social ordering by way of judicial process. The Apex Court has tried to eliminate socio-economic evil of bonded labor, including child labor, and issued certain guidelines to be followed, so that recurring of such incidents be eliminated. Caste system and judicial process. In Lata Singh v. State of UP, AIR 2006 SC 2522. The Apex Court has given protection to the major boy and girl who have solemnized intercaste or interreligious marriage. Child labor. In MC Mehta v State of T.N. AIR 1997 SC 699, the Supreme Court has issued direction the state governments to ensure fulfillment of legislative intention behind the Child Labor, Prohibition and Regulation Act 61 of 1986. Tackling the seriousness of this socio-economic problem, the Supreme Court has directed the offending employer to pay compensation, a sum of Rs 20,000 for every child employed. Child prostitution. In Gaurav Jain v. U.O.I. AIR 1997 SC 3021, the Apex Court issued directions for rescue and rehabilitation of child prostitutes and children of the prostitutes. Dowry death. Dowry death is perhaps one of the worst social disorders prevailing in the society, which demands heavy hand of judicial process to root out this social evil. In Raja Lal Singh v. State of Jharkhand, the Supreme Court has laid down that there is a clear nexus between the death of Gayatri and the dowry-related harassment inflicted on her. Therefore, even if Gayatri committed suicide, S304-B of the IPC can still be attracted. Equality, man and woman. In AIR India v. Nargesh Meerza, AIR 1981 SC 1829, the Apex Court declared that the provision of AIR India Service Regulation 46, I.C., or on first pregnancy whichever occurs earlier, is unconstitutional, and is violative of Article 14 of the Constitution. Female feticide and judicial process. Leading to unhindered female infanticide affecting overall sex ratio in various states, causing serious disorder in the society. In Center for Enquiry into Health and Allied Themes, Sahat v. Union of India, AIR 2001 SC 2007, the Apex Court has held that despite the PNDT Act being enacted by the Parliament 5 years back, neither the state governments nor the central government has taken appropriate actions for its implementation. Hence, directions are issued by the court for the proper implementation of the PNDT Act, for eliminating this social evil. Goal of judicial process. Ultimate goal of judicial process, undoubtedly, is to ensure social order and to make the society safer for its people. Law cannot be effective and useful without taking recourse of judicial process in maintaining social order. Justice P. N. Bhagwati and Justice V. R. Krishna Iyer, both were of the opinion that law is an instrument of social change, social justice and social ordering. Justice Ranganath Mishra, former CJI, has rightly observed that law is a means to an end and justice is the end. Therefore, undoubtedly we can say that judicial process, which operate laws, is an instrument of social ordering. Harassment of women. The Apex Court in Vishakha v. State of Rajasthan, AIR 1997 SC 3011, created law of the land holding that the right to be free from sexual harassment is fundamental right guaranteed under Articles 14, 15 and 21 of the Constitution. The court has issued guidelines to be followed by employer for controlling harassment of women at her workplace. Immoral trafficking. Immoral trafficking has now become a widespread social disorder. This is a deep-rooted social evil has to be controlled. The Apex Court is of the opinion that accused persons are to be dealt with heavy hands of the judicial process in such cases. In State of Maharashtra v. Morg, Sajid Hussain Morg, S. Hussain, AIR 2008 Supreme Court 155, the court has rejected application for anticipatory bail, in a case where a minor girl was driven to flesh trade by accused persons, comprised of police officers, politicians and all were absconding for long time. Judicial process and social order. It is satisfying to see that achievements of judicial process in respect of social ordering has been significant. Judiciary has not shied away from its responsibility of enforcing social order. Looking to the need of our and demands of the changing society, the Supreme Court has innovated various tools and techniques for securing social order. One can see how the Supreme Court of India has innovated, case after case, various juristic principles and doctrines for upgrading social order. Needless to say that Articles 14, 15, 16, 17, 38, 39A and 42 to 47 of the Constitution of India deal with facets of social justice. Courts have played very wide role in interpreting the connection for achievements of social justice. Maintenance. In Mohg. Ahmed Khan v Shah Bano, AIR 1985 SC 945, the Apex Court, for the first time, granted maintenance to divorced Muslim women under Section 125 CRPC, ignoring her personal law, keeping in view essence of equality before law. In Dimple Gupta v Rajiv Gupta, AIR 2008 SC 239, the Apex Court has granted maintenance to illegitimate child under S 125 CRPC. This path-breaking judgment has given breath to the innocent children who were victim of no fault of their own. These verdicts are judicial instruments of social ordering. Need of judicial process. Noble preamble of our Constitution promises citizens of India to secure justice, inter alia, social justice, transforming social order. Judicial process has played a significant role in order to deliver social justice, by eliminating socio-economic imbalance and social injustice from the society. Outraging modesty of woman. Outraging the modesty of a woman is a serious social disorder has to be taken seriously by courts during the course of judicial process. In Kanvarpal S. Gill v State, Adm. UT Chandigarh, the accused slapped on the posterior of the prosecutrix, Mrs. Rupan Deol Bajaj, an IAS officer, in the presence of other guests. The accused, who was then the DGP of the state of Punjab. The CJM convicted him under sections 354 and 509 IPC. Appeal filed by the accused was dismissed by the Apex Court. That by itself is setting a model for others, and it is a good example in connection to social ordering. Prevention of atrocity. When members of the SC and ST assert their rights and demand statutory protection, vested interest try to cow them down. In these circumstances, anticipatory bail is not maintainable to persons who commit such offences. Such a denial cannot be considered as violative of Article 14 as held in State of MP v R.K. Balothia, AIR 1995 SC 1198. Rape. In State of MP v Babulal, AIR 2008 Supreme Court 582. The court has laid down the principle that rape cases need to be dealt with sternly and severely. A socially sensitized judge is a better armor in cases of crime against women. Once a person is convicted for an offense of rape, he should be treated with a heavy hand and must be imposed adequate sentence. This goes to show that how the Supreme Court is keen in eliminating social disorder by the heavy hands of judicial process. Conclusion. Justice V.R. Krishna Iyer has rightly observed that law is not a brooding omnipotence in the sky but a pragmatic instrument of social order. Judicial process is a means of enforcing law. In the light of the above discussion, certainly it would be perfectly right to say that judicial process is an instrument of social ordering. The prominent work of Indian courts today may be seen as prosecuting poor people for petty crime. The main role of courts continues to be, as in colonial times too, enforce law against, mostly poor, citizens, 2. Protect property rights, state and private, and 3. Uphold and protect the authority of state. On the other hand, in the immortal words of Supreme Court in S.P. Gupta case, the Constitution has made a revolutionary change in the role of Indian courts from being an arm of the Raj to being an instrument of Swaraj, an arm of social revolution.